everyone, welcome to Immigration Talk on Indus TV. I'm your host Kartika, and today we have with us attorney Poonam Bhuchar from Bhuchar Law Firm. Welcome Poonam.
Hi Kartika, how are you?
I'm doing well, how are you?
Good, thank you.
Welcome to the show.
Thank you for having me.
For today's Immigration Talk, we will be discussing a very important yet very confusing topic which is important to a lot of people these days. We will be discussing and asking Poonam some important questions about Form I-140 and I-485. Poonam is here to help us answer those questions. So Poonam, this is a very important topic these days, especially considering the current circumstances, and we would love to have some answers for some very nerve-wracking and confusing questions.
Absolutely. We have clients asking us questions regarding this all the time.
Yes.
It's an extremely important topic.
Yeah. So just to start off the conversation, can you tell us a little bit about the backlogs which are being faced by a lot of people these days for the immigrant visas?
Right. So currently, as you know, the fiscal year for employment-based any kind of visa for green cards happens from October 1st of that year to September 30th. And I'm talking about visas outside of people that marry U.S. immediate relative green cards. So that's the fiscal year from October 1st to September 30th, and each year there's 140,000 employment-based green cards available. And there's a cap per country of 7%, which equates to about 9,800 visas for each country. So the issue with countries like China and India are that they're being pulled in the same category as people who have smaller countries, like for instance the UK has 7% of visas and India has 7% of visas, but the population in India is much larger and the people coming over is much larger, hence the huge backlog. What we are hoping is that, as you know, on June 2nd, the EAGLE Act was introduced by Representatives Zofran and John Curtis, which is trying to eliminate the per country limits, which if it does go through, hopefully will help Indian citizens and people from China. But as you know, this has been going on for
years now.
So
yes.
We'll have to wait and see what happens.
Yeah, there has been traction, but then it never passes
exactly.
through the houses. So
we're hoping with the new administration, things may move, but
and
we'll have
with
to wait
immigration
and see.
being their prime focus, one of their prime focuses, we can hope this might get through this year.
Certainly hope so.
Okay. So as we were talking about the bigger countries and smaller countries for the impact, what is the impact on Indian nationals specifically because of this backlog?
So given the per country limit, I mean, there's no accurate estimate, but the studies are showing that if anyone, you know, the wait for green cards, if anybody were to file today or the last couple of years, you're looking at anywhere from 150 to 196 years.
Really?
So essentially what you're saying is that people who've been in this country could have kids, could have grandkids, may still not end up having a green card, and they would have paid taxes, they would have been able bodies in the US that have contributed to the economy, but yet they're not able to obtain a green card.
Not in their lifetime, 150 years?
It's absolutely absurd. So obviously something has to be done, and I would argue that something needs to be done as soon as possible given
right now
the backlog. I mean, I can tell you in our office, we're seeing people thinking about obtaining visas or permanent residency in different countries, looking at the situation here. So imagine what that does to the pool of talent that is coming into the US. It shrinks it.
Considering it's like 2021, and as far as I know from the last bulletin, the dates for so-called the dates to file for the green card was 2010, 2011. That means we are still looking 10 years back. So
at minimum, and for it to shift absent October of 2020, where there became more visas green cards available, because the family visas spilled over.
Yes.
Absent that, it takes 10 years to move, even a few months sometimes, and it's so crazy. And especially when you compare it to other countries like the UK to get permanent residency, or Canadian permanent
Yes.
residency, you're talking about a couple of
Couple of
years,
yes.
versus 100 years.
100 years, that means not this lifetime. So it's disheartening.
It's very
really
disheartening for
yes.
people that have come and work here and contribute.
And it's disheartening for their kids, the entire families, the dependent spouses.
Absolutely.
So it's not just one person who's losing out, it's like the entire family which is suffering for that.
Absolutely. And when you talk about the kids, you're talking about somebody who could file for a green card when their children are 10 or 11. Their kids won't get the green card
Right.
because they would have maxed out, aged out, and then they will have to come up with their own path of obtaining their own green card. It's a complete nightmare.
And it's
for
a vicious
people.
circle. If the parents are not getting it, the kids are not getting it either, because
Exactly.
the dates are not moving.
Right.
It's a very tough situation. Okay, and continuing on this same topic of 485s, when should an employer file for a supplemental J form?
So Supplement J really took over before when people used to switch jobs under AC21. We used to just write in letters to immigration to let them know. A few years back, there's now the official Supplement J. So anytime you switch employers, you should file a Supplement J before switching the employment, or at the time of switching in the employment, to notify immigration. For people who haven't done that, who have 485s filed, they can file it at the RFV stage. But I definitely do recommend that before switching jobs, or at the time of switching jobs, that you notify immigration.
So Poonam, finally after a long wait, people got a little relief when the date started moving in October of 2020, and people saw, especially the EB3 category, as we were talking, lack of family applications. So now people are confused whether they should downgrade their EB2, especially the employer-based EB2 applications, to EB3 applications since the movement in dates. Can you shed some light on that?
Yeah, I think we have to remember that downgrading is downgrading the I-140 petition.
Okay.
And that is owned by the employer. So the employer would have to agree to be able to download the petition. And I think you need to go by a case-by-case basis, and it would involve reaching out to our office or any other attorney and having the case reviewed to see if it should be downgraded. And obviously you have to have your employer on board in order to downgrade the petition. So it is definitely something worth considering. And there are ways that you can do it where you can potentially keep both petitions, EB2 and EB3. But again, it has to be done with the permission of the employer.
That was about to be my next question, that if we downgrade, do we still maintain the EB2 or it's just the EB3? But as you said, there are ways to maintain both.
Yeah, there are ways to maintain both, and it depends how it's filed, whether it's filed as a new petition or it's filed as an amendment. And there are ways to keep both so that you can use it interchangeably. So if the EB3 date is current, and then your attorney can write the letter to interchange it to the EB2 if USCIS doesn't do it automatically. But I do really think it needs to be looked at on a case-by-case basis.
And the employer needs to be on board.
Absolutely.
Okay. So are there any circumstances between all the shuffles between EB2 and EB3 and downgrades that I-140 can be revoked?
Well, yeah. I mean, so any I-140 that's been pending for 180 days under the memo cannot be revoked absent fraud, willful misrepresentation, or a material error in the application. If an employer revokes the I-140 within the 180 days, then the employee can retain the priority date, but the petition has gone, so long as there was no, again, fraud or misrepresentation.
So it's on the employer to revoke or not revoke. But is it usually done by the employer, revoking of 140s?
You know, I will tell you that a lot of employers don't do it.
Okay.
A lot of employers have started to do it for the reason being that a lot of the times when you file I-140s for employees, a lot of the times we're getting RFEs that is
Right.
asking for a list of employees whom you filed I-140s
Okay.
on. So that affects the employer's ability to pay. So a lot of the times they will now revoke the I-140s where people have left their
Left the
company
company.
so that their records are clean.
Yeah, as long as the employee is working, the employer keeps the petition, but it's okay to revoke it if the employee is no longer with the firm.
Right, and I'm seeing more and more employers, that
Right.
want to do this because they want to keep
Keep
the
the-
records clean.
Coming back to I-485, I think it's when people start feeling that their green card is almost there when they file it. Can they switch jobs after filing for their 485s? That is a very common question which we come across all the time.
Yeah, and people are, as you said, some people are eager to quit their
Yes.
jobs and move on. So when there is a 485 pending, under certain circumstances, under what's called AC21, as long as your 485 has been pending for 180 days,
Okay.
you can switch employers, but the new employment has to be in a same or similar position.
Okay.
And same or similar position can be defined not just by the SOC code that the perm application was filed in, but it could be a progressive employment. It could be taking into account your skills, your education, your position. And I would recommend anyone that is thinking about switching jobs to consult their attorneys before they do so.
Okay.
The other thing to remember is that this is my personal recommendation, and I know it's a gray area where we may have differing opinions, but if you have an I-140 downgrade, and that I-140 downgrade has not been approved,
Okay.
even if your application has been pending for 180 days, I do not recommend switching jobs, because
Okay.
if anything happens to that I-140, and that is the basis of you filing the 485 application, you could get yourself into a lot of trouble.
And could you potentially lose your priority date as well in that case?
Well, you may not, there may be ways of recouping the priority date,
Okay.
but you will lose the 485 application, you could potentially be out of H-1B status, and it could create all kinds of issues. So
a lot of chaos.
a lot of chaos, so please, before doing anything like that, consult your attorneys.
So Poonam, again, a very confusing thing, and I have seen a lot of discussions about that USCIS uses two columns, date of filing and final action date. Can you shed some light on what is the difference between the date of filing and the final action date, and how does that matter? How is it so important?
So the last couple of years we've had, as you said, these two columns,
Yes.
right? And the final action date means that the green card is available now, okay?
Okay.
The date of filing is the dates that are anticipated to become current in the next 6 to 12 months.
Okay.
And what happens is USCIS makes a determination every month whether they're going to accept the date of filing. So if you remember, in October of 2020, November 2020, and December, there was the dates of filing that were accepted, which meant that a lot of the EB3 categories were going up to 2014, and people were filing all their green cards. That doesn't mean that the green cards are absolutely available now. It meant that they're anticipating those dates will become current based on the number of visas that are available. So in the last couple of months, USCIS has not been accepting dates of filing, but it gives you an idea when you look at the visa bulletin that maybe you should or should not start preparing your documents. It's a good gauge to have.
Because as per the current visa bulletin which I read, they are now working only on the final action dates.
Right.
They are not accepting.
And that's what typically happens if we go by the history of the last couple of years. We've seen October and maybe November that they accept it, but it hasn't been as frequently as we had hoped. But it is a good gauge to see when you should start preparing your documents.
Slight hope.
Slight.
Moving on to a question which bothers a lot of families, especially where the kids are not US citizens, they are born in India and brought to US. They age out of the system, the dependent age. I want to talk a little bit about that. What is the age where they move out of the system, and what is the Child Protection Act? Can the parents do anything about it?
So it really, I hate to say, it really does depend on a case-by-case basis. So the Immigration Nationality Act defines a child as somebody who's under 21 and unmarried, okay? And the Child Status Protection Act came into place to protect certain family members in different scenarios. And there are different, I call them mathematical formulas, that you can implement in different cases. So for the employment-based case, it would depend how long your I-140 petition was pending. And say it was pending 8 months, and the time of the green card, your child has already hit 21. They would almost have a window of 8 months in which you hope that they receive their green card beyond the 21. If they don't, then they have aged out, and that's where we talk about the backlogs, and they have to have their own path.
Their own path, like F1s or H1s or things like that.
Yeah, the case has to be looked at, the formula has to be implemented, and while it may protect some children who are on the cusp, those who are years beyond, it will not protect.
It will not protect them. So there is no specific one answer that fits all families.
No, no.
Okay. So that was a wonderful discussion, Poonam. Before we wrap up, we have a couple of questions from the audience, and I would like to play the first question for you.
Sure.
Hi, my name is Priyanka, and my question is, can I be on H-1B visa even if I got my EAD approved? Thanks.
In short, yes. We definitely recommend in our office that people maintain their H-1B status even if they have an EAD approved, because if anything happens to the 485 application, then they have a fallback position with the H-1B. There are also other situations in which H-1Bs in certain have other protections, such as if you violate or out of status for a certain period of time, they may be forgiven, whereas under EADs they are not. So in short, the answer is yes. If you use your EAD, it's a different question. And when I say use your EAD, if you're with the same employer and you showed that employer the EAD to complete the I-9, then you have used your EAD. Obviously, if you switch employment and you've shown it, then you've used your EAD. But generically, if you have an EAD and you're not using it, yes, you can maintain your H-1B.
A question just popped in my mind. Can we transfer H-1s after that, or we have to use the EAD if we switch employees?
No, you can transfer the H-1Bs. But obviously, you need to see the impact on your green card and your I-140 before you do that.
Okay, and moving on to the next question from our audience.
Hello Poonam, my name is Madhavi. My question is, once we downgrade from EB2 to EB3, is it possible to move I-140 petition to premium?
So Madhavi, yes, it depends. Sometimes it can take longer than usual, especially where the downgrades from EB2 to EB3. If it's not at that particular service center, we're receiving RFEs when we send the premium processing check. I'm sorry, not RFEs, we're receiving notices back saying that they will try and retrieve the original perm or the original I-140 from the previous service center, and that we should try back in 30 days. A lot of the times we have tried back in 30 days and we have managed to upgrade the petition, but it may just take longer than you expect.
Longer than the actual premium processing times.
Yes.
Okay. That was wonderful, Poonam. Especially the audience questions. I think they got some peace of mind listening to your advice, and I hope this brings peace of mind to a lot of our audience. This was a very, very important topic. Thank you so much for shedding light on these questions.
Thank you for having me, Kartika. It's been a pleasure.
For any legal services, please contact Poonam. Her email address is poonam@bhucharlaw.com. This is your host Kartika signing off. Thanks for watching.